Matter of Clifton Park Apartments versus DHR.
May it please the court, I'm Tony Ann Hollifield for the Division of Human Rights. I'd request to reserve 3 minutes for rebuttal, please.
Yes.
As a matter of public policy, in order for the human rights law to be effective, complainants must be able to file good faith discrimination complaints without fear that they could be sued for the content of those complaints. Finding otherwise would be against the public interest recognized by the legislature when they enacted the law and would have a chilling effect on those seeking to assert their rights under the statute.
So if I could just to be clear on this, what I think is a threshold question for me, the division interprets the statute and the case law to require a good faith complaint, even though those words are not in the statute.
Yes.
Okay. Do we actually have to decide that now?
Well, the commissioner found that in the instant case, there was the underlying original complaint filed by City Vision was made in good faith. After the initial investigation, the division dismissed that complaint for lack of probable cause. But in this succeeding retaliation complaint, the commissioner did find that the initial complaint was made in good faith.
In good faith. So why has the division come to this interpretation, since good faith, those words are not found in the section on retaliation?
Well, there's case law to that effect.
Whose burden was it supposed to be to establish the good faith? Was it City Vision, or was it the owner to establish that they didn't have good faith?
It's the complainant's burden, the initial burden, to show that the complaint was made in good faith, and then the burden shifts
And below, was that done?
at the division.
At the division.
In this case, the commissioner did not make a numbered finding of fact to the effect that there was a good faith initial complaint. However, he did find that the complaint was made in good faith. And that is final order at page 5, which is
But that's a
73
fact
of the record.
finding. Is that not a factual finding? You're
It
saying
it
that's
is a
not a
factual
factual
finding,
finding?
but
Okay.
it's not a numbered finding of fact.
Oh, I see. Oh, I'm sorry.
as
Now I
part of
understand.
the final
Is that
order.
in part, well, let me ask it this way. Could the division have relied on the proceedings, or its assessment, I guess I should put it that way, its investigation, with respect to the initial complaint? When you're making this determination, let's try it this way. When you're making this determination about whether or not it was filed in good faith, is the division limited only to whatever is presented in that proceeding, the retaliation petition proceeding? Or can it can it take internal notice of the prior proceeding?
No, the division is limited to the evidence that was presented at the hearing when determining a final order after hearing.
So back to Judge Troutman's question, does the burden shift when you go from the original complaint to the retaliation claim? Is it now, New Vision, I forgot their name.
City Vision.
City Vision. Is it now their burden to show that the complaint was made in good faith?
It's always the complainant's burden to show that the complaint was made in good faith.
Okay.
And so
And-
the appellate division said that that burden was improperly shifted, or that there was no analysis as to that statement that it was in good faith. So do you dispute that finding by the appellate division?
We do. While we understand that generally there are numbered findings of fact and that this was not in that portion of the order, there was a very direct statement from the commissioner that the initial complaint was made in good faith.
And what would have been the basis for that determination? If you're saying that you're limited only to the record before the ALJ here, based on this petition?
It would have been the
Is it some testimony? What would you say?
But is there any indication in this finding? I mean, you can say something, but how do you review it if there's no indication, or I think as the appellate division says, no analysis of why they reached that conclusion? Right? It's just, it was made in good faith, but there's nothing else. So how is the court supposed to review that finding for any support in the record?
Well, we understand that the third department felt that there was not sufficient analysis. And they did mention in their order that generally that would mean the matter would be remitted to the division for further analysis.
Can you point to anything in the record that was analysis?
No, the order itself simply says the initial complaint was made in good faith. There was no analysis in the order.
Counsel, on the material adverse effect, where in the record can you point us to something that shows a material adverse effect? Maybe you can start by telling me what exactly are you claiming is the material adverse effect?
Yes, Your Honor, the adverse effect was the threatening letter. The letter itself.
But doesn't the letter have to have, even if we were to agree with you that a letter could have some material adverse effect, is your argument that it is per se sufficient, or and there doesn't need to be anything in the record that shows that it in fact had some effect, or is there something in the record that demonstrates that effect that you want us to look at?
Well, Your Honor, the threat itself was the adverse effect. It's clear from City Vision's subsequent actions that they felt threatened with.
Okay, so where, on that point, where in the record is that established that they felt threatened?
Well, within 2 weeks of the date of the letter, City Vision started drafting their retaliation complaint.
But doesn't City Vision need to show that the letter had some material effect aside from that they decided to file a retaliation action? It seems to me maybe that's bootstrapping a little bit.
It's the division's position that the chilling effect of the threat of litigation for the content of a discrimination complaint is sufficient for a finding of retaliation. As I said, in this case, it's clear the City Vision felt threatened. It was less than a month between the date of the letter and the filing of the retaliation complaint.
So is that because in order for them to be able to fulfill their mission, they need to be able to file a complaint in good faith?
Yes. And it's not just City Vision. It's all complainants. This decision would not be specific to City Vision or an advocacy organization. All complainants need to be free to file discrimination complaints that they're making in good faith without the fear that they can be sued for the content of those complaints. The majority of complainants are individuals.
And would that result in one being unable to challenge those that were not filed in good faith?
No. The threshold issue that the underlying complaint had to have been in good faith is necessary. If there is a complaint filed in bad faith for some reason, that would not be protected.
But your argument sounds I'm sorry, over here. It sounds a little like you're saying, even if City Vision had said, this didn't chill us at all, but we decided to file a lawsuit to vindicate rights of others, that would be sufficient for an award against the apartment building, right?
Well, City Vision is an advocacy organization, so they're always going to be filing complaints on behalf of.
What I'm trying to get at is, it sounded to me as if you were sort of answering a question that Judge Halligan asked earlier, which is whether you were saying this is really a per se violation, so you don't need to show any material adverse impact to the particular party here.
Well, the impact on City Vision itself is the diversion of their resources.
Yeah, but suppose that they said we don't care about that, or something like that. Or is it, because you seem to be articulating a policy reason that because there are many of the people in these circumstances are not testing companies, but they're individuals, it really kind of doesn't matter, that if an organization, the landlord is in the business of sending threatening letters, that's going to result in a sanction, even if the particular party wasn't adversely impacted in any way. Is that your position or no?
No, but because we believe that the adverse impact is the chilling effect that that threat would
But
have.
the chilling effect of others or the chilling effect of this particular?
This
litigant?
particular person, maybe they, sometime down the line,
And
something
so if they
else
affirmatively
occurs.
said, we weren't chilled at all, in fact, we were energized by this, then what?
I think that would be a fact-specific inquiry
Well,
in that
I'm asking
situation.
hypothetical facts now and asking you for the result.
I'm not sure how the division would rule in that.
I'm sorry,
instance.
I thought as the chief judge was getting at, I think, trying to explore, is that it isn't only the chilling effect on the particular party here. So if a tenant gets a letter like this for filing a complaint, and this same thing would have happened, it's the effect on other tenants in the building as well. The chilling effect on their coming forward with similar complaints. Isn't that your argument, or is it that the particular tenant involved in the proceeding has to show they were somehow chilled or suffered some adverse consequence?
I think it's both. If it's a,
Do you need both?
no, I don't believe you need both. I'm sorry, the light was distracting. But in this case, as Your Honor said, if it's a building where one person filed a complaint and was threatened with a lawsuit, or if it's an employer where one employee filed a complaint.
Let's say that building, and someone files a complaint, one of the tenants, and it's dismissed. Same facts here, they send this letter. And that tenant in the proceeding says, no, I didn't feel chilled at all. In fact, I filed another complaint the next week, but this still was an adverse action. Do they recover or not? Do they win or not? Based on the fact that other tenants might have been chilled.
Again, I believe that would be a fact-specific inquiry that I can't
But isn't
answer.
then this just a fact-specific inquiry too? So if you don't, as Judge Halligan, I think, was getting at, if there isn't sufficient information in this record about this particular party, then you lose on the fact-specific inquiry.
But in this particular case, while City Vision was adversely affected, they were threatened, they felt
And
threatened.
I understand that argument.
And in addition to that, there was a diversion of resources that went into filing the retaliation complaint and dealing with the investigation. They hired counsel in that instance, in the retaliation complaint. So all of that goes toward their adverse.
So as a general matter, when you're assessing, I'm over here, when you're assessing a complaint, do you look to see if there is an adverse effect that particular complainant has provided evidence of, or instead do you assume that if a threat is established, that alone constitutes a material adverse effect? I don't just mean in this case, but more generally, what is your practice?
Generally, there needs to be an adverse effect on the individual, or by individual complainant, I mean the person or entity filing the complaint.
Okay, so what I'm grappling with here is where that is in the record, because it seems to me that one individual says, I think the word he uses is that he was shocked. And there is some expenditure of resources, and correct me if I'm wrong, but it looked to me like, although it was a little hard to tell, almost all of those dollars were related to filing the retaliation complaint itself, as opposed to some effect, independent of the dollars spent to bring the retaliation claim. Is there anything else in the record I'm missing?
No, that is, on this record, that is the extent of the for lack of a better term, damages suffered by City Vision. But if you look at the dollars spent going toward the retaliation complaint, that was filed in direct response to the letter that threatened that the respondents at the division level would proceed accordingly, which certainly seemed to the commissioner as if a lawsuit was forthcoming. And they filed that retaliation complaint to get ahead of that forthcoming litigation.
So if I'm understanding you, you're arguing that they took the threats seriously,
Yes.
and they were concerned they might be liable, and they were trying to protect themselves, and therefore you have the adverse effect?
Yes.
Yeah, well, it's really adverse action, right? It's adverse action,
Yes.
which you're calling it adverse effect, but I understand the case say adverse action.
That's correct.
Thank you.
Good afternoon, may it please the court. The issue before the court is an interesting one. It's something that the court has not fully addressed. Mainly, the basic framework of retaliation claim was set forth by this court, by Judge Kaye, in the forget the name of the case. But the fifth element now that's being added is, what about now when the complaint has been found to be totally meritless? Can there be a retaliation claim based on that? This court in the matter of Mohawk left it open and decided there are two ways of going with it, decided that on the record we're not going to handle it. But then the appellate division, starting with the third department, we set this argument forth in our brief at page 26. In matter OMRDD Staten Island, said we're going to adopt the federal standard. And that federal standard is that when the complaint has been dismissed, the alleged discriminatory complaint has been dismissed, the plaintiff must show, the complainant must show that they had a reasonable basis to believe. I'm not sure this good faith, I've been reading good faith as meaning the shorthand version of human rights is saying that's the reasonable basis, but the test is one of reasonable basis. And there is no proof of that. Now, they keep on talking about a good faith basis
So
in
if
the
I can-
order.
if
Well,
I
the
can
order
ju-
is set forth.
Counsel, I'm sorry. I can just be, I'm over here. I can just be clear.
I thought it was over there.
No, that's fine. I can just be clear. You're saying we have left open the question whether or not, whether you call it a reasonable basis or good faith, there has to be something beyond perhaps a malicious intent or no grounds, let me put it that way, for filing the complaint, when the petition, when of course the division finds lacks probable cause of actual discrimination. And your position is we should now also adopt this federal standard that the lower court has adopted? Is that your
Yes,
position?
I think that this standard has been working very well. There's been no complaints with it.
So let me ask this. Since I don't see any of this in the statute, what would be the basis for adopting this particular permutation of a
I
standard?
think the basis here is now trying to do a workable standard, recognizing that we do not want to abridge and deter people from filing complaints. But on the same point, we don't want to encourage people to file bogus complaints.
But isn't there already something in the statute that deals with that, which was the opportunity, of course, and this includes your client, to seek attorney's fees for basis when a frivolous complaint is
Yes,
filed?
and I will address that, Your
So
Honor.
could not the legislature have decided, we don't want to go about the business of having courts figure out what is and is not a reasonable basis in good faith. If it's frivolous, fine, pay the attorney's fees, and that will be what discourages that kind of conduct, because the real problem is encouraging people to file, not discouraging people to file who have no basis.
Right. No, I fully agree that this court can, and it's a question really of statutory interpretation, which this court is suited for. You don't have to defer to human rights. It's a matter of pure statutory interpretation. And what I state is that what the feds have done and the lower courts have done is that this reasonable basis no pun intended, no, it's a reasonable accommodation of everything. But getting back to this, now, they keep on talking about the order at page 5. This is reprinted in the record at page 73. This is their finding of good faith. Accordingly, as complainants seeking a good faith basis claim. But there's no proof of that. And the reason why there's no proof of it, Your Honor, is that the party who brought this case brought it on the theory that all I have to do is show the letter was sent, and that's it. Relying upon Judge Hark's decision back in 1972 that that's enough. They never brought forth any evidence to show reasonable basis. The witness list was Mr. Penkowski, the attorney, for Clifton Park, and their own inside person who was going to talk about damages. They never brought forth anything to show that they had a reasonable basis for doing so. And then when you look at the
What would, I'm over here again. I'm sorry. No, I'm sorry.
It sounds like you're coming from there.
I apologize.
Not trying to ignore you, Judge.
No worries. From your perspective, given the standard that you're advocating for, what is it that a complainant, your client, the complainant here, excuse me, City Vision, would have had to have done to avoid perhaps
They would have
finding
shown
that
that
they didn't have a
they
reasonable basis?
investigated reasonably.
Okay.
And again, if you look at the
Does
initial...
that, let me just ask you, does that quote-unquote investigation have to equate with the kind of investigation the division does?
No.
Okay.
Some basis. Now, all the record shows is that they bought a directory of apartments in New York State and made cold calls. They did nothing further. If they just simply put on the internet, Clifton Park Apartments,
Yeah.
Shenandoah Schools.
Counsel, I'm sorry to interrupt, but I have a question on just the standard on reasonable basis. In litigating this, did the agency ever say you don't need to show reasonable basis? Was that an issue here? I thought the issue here was, is there a sufficient finding?
No, the agency has never done that. In fact, the agency has followed the reasonable basis standard in all their other decisions. So, I mean, they're agreeing with it, but there's the disagreement that I have with the division now is that there is no proof of that.
That, I understand that. So in this case, there was not a dispute between the parties over whether you needed to show a reasonable basis. It was only whether it was shown or found.
No dispute at this stage, Your Honor. Like I said, I think a lot of the fault in this case has to be given to the initial attorney for City Vision, who proceeded on a basis that was ignorant of New York law. That's why the record is so bereft of any proof, not only of reasonable basis, but adverse action.
Can I ask you about the impact of the attorney fee provision in the executive law in Section 10? I think you said you were going to address that. So should that inform in any way how we look at this? And let me ask it the following way. As I read it, and there may be a different way to read it, to be able to recover attorney's fees, you need two things. One is you need to demonstrate that the complaint was frivolous.
Correct.
But it also, and there's a definition of frivolous, but it also says that it has to be after a hearing of the kind in Section 4. So there's a way to read it to say that if all that's happened is a complaint is filed and it's thrown out before a hearing, you can't get attorney's fees.
Correct. You have to start another proceeding before the commission to seek reasonable attorney's fees. You start another hearing. Now, that backs into, Judge, and I'm going to cut you off, but that's why we say here that initially, that adverse action requires some adverse action. And the adverse action here starts with that letter that Mr. Penkowski sent. And the letter says, we're going to look for you for damages. Let's sit down and talk. Let's try to resolve this. If we don't hear from you, we will proceed accordingly. Never said, I'm going to see you in federal court tomorrow or whatever.
Counsel, if the letter had said, if I don't hear from you by such and such date, we'll file an action.
That could have
Begin our
been,
lawsuit. Would that have been enough?
that could be enough, could be enough.
Okay.
But again, even that though, Your Honor, here's the problem. if we say, see you in court, but if they had said, we'll see you in the back before Division of Human Rights to get our attorney's fees, that would have been proper. So what we're saying here is that when you say here, we're going to proceed accordingly, they had the right to proceed before Division of Human Rights to get their attorney's fees.
But the complainant knows that in advance, because that is a possibility, right?
Right, they're saying the right that they have to do. And you can't say and what's trying to be done here is now, you can't do that. Now, so what good is that attorney's fees application for?
That is different from saying we're going to drag you into court and seek damages, not just fees.
Possibly.
Ruin your name, you'll lose all that funding, you're a not-for-profit.
Well, again, not for profit, but this really is a money-making operation, Your Honor. I mean, I'm not trying to besmirch. I think these testing agencies do God's work in ferreting out discrimination. They're a major adjunct to our agencies that don't have the manpower. I mean, the Supreme Court, the United States Supreme Court has endorsed testers with working with the NAACP and other civil rights organizations to find this out. But here, what this testers agency did is really for commercial purposes. And when you look at it, within 2 weeks after the complaint was filed, they send a conciliation letter. Oh, we'll take care of everything. Pay us a couple of $1,000, take our courses that we offer, and we'll forget about it. We will go to, whether it's the HUD or SDR, to vacate everything. And then after they sent that, Mr. Penkowski kept on calling them, tell us what we did wrong. And they never responded.
Counsel, can I follow up on Judge Garcia's point here? I think I understood his point. If both sides, or at least the division and you, agree that the standard is reasonable basis, good faith, however you're calling it, can the court revisit that in this case, since we've left the question open, to determine that, or do we have to accept that that's the standard that you're working with?
This is the conundrum that I had, Your Honor. In my last point, I go along with what the appellate division said, is that we have to give the agency the first crack at applying the proper standard. Now, I would like to say in that regard, if they apply the proper standard to this record, there's no basis. There's no basis whatsoever to conclude the reasonable basis is there, because there's no evidence. And I would have loved to have said that, but I found no case that says that that a court can, when the agency uses the wrong standard, that they can use the standard. You always have to give the agency the first crack. Now, I'd love this court to say, unless there's no basis for it. But I found no authority to make that argument. I would love to have found authority for it, and trust me, I did a lot of work looking at that. But I think here, what the appellate division did is simply saying that's normal course. But then they found that there's no adverse action, which is the other point now. That adverse action, obviously when the tenant is now files a complaint and then he's thrown out of the apartment, or the lease is terminated, the employee is fired when he files the complaint. That's your classic adverse action. But remember, this is being done in the context now of a tester agency.
Well,
And
do you
this
think
tester
do you
agency,
think the appellate division exceeded its review power to find that the letter was retaliatory instead of deferring to DHR and their findings? Like, what are we to do with that?
no, I think there, the appellate division, that last part of the decision, Judge Singas, acted properly, and the review said substantial evidence. There's no substantial evidence showing that that adverse action element was satisfied.
But don't we have to defer to DHR on that?
No.
On their findings? Why not?
Because you have the substantial evidence review power, and that's what the issue is.
What would, over here, what would the substantial evidence be? The DHCR looked at the letter and said, this is retaliatory, this is adverse in some way. And the appellate division simply disagreed with it. The evidence is the letter itself and nothing more.
It's two different issues, Judge. I mean, certainly, and I make this argument in my brief, my argument is that I don't think that letter is a threat to sue. And
You're entitled
but
to
I
that.
also recognize that that may be something that you would defer to the appellate division, defer to human rights. But the impact, where's the impact?
Well, they say the impact is the fees that they had to pay for counsel, right? That's their argument.
The only impact here is that they want to now start a lawsuit.
Right, and that's what they claim.
There's nothing interrupted their business, there's nothing to show anything like that.
But but isn't the argument that I feel threatened, I've got to protect myself, I took these actions, and that cost me resources and money.
Well,
If I hadn't gotten the letter, I wouldn't have had to do any of those things.
again, Your Honor, that's one way of looking at it. The other way of looking at it is take up Mr. Penkowski's offer. Call them up. What exactly are you looking at? What are you seeking? And resolve it that way. But don't run now to get a lawyer to bring an action without really thinking it through.
Well, suppose we
I
change.
see my time is up.
Suppose we change the facts a little bit and give you a hypothetical. Suppose instead of a testing company, this had been an individual tenant, and the landlord's lawyer sends a letter saying, unless you vacate the apartment, we're going to take all legal means necessary, or, we reserve our rights to proceed accordingly, whatever the letter says. I think proceed accordingly, right? And the tenant then goes to court to get a declaration, or goes to human rights to get that declaration that they can't be thrown out, and incurs some legal fees. Do those legal fees not count as adverse, as a material effect adverse?
In that situation, yes.
So is the difference there just that it's the testing company and not the individual tenant?
No, I think the difference is, Your Honor, there the legal fees were actually incurred as a direct result of the wrongful conduct of the landlord. Here, again, all he did is said, let's sit down and try to resolve this.
But
And they
doesn't
pushed
that
the panic
turn
button.
on, doesn't that turn on how we read the letter? In other words, if we disagree with the way you are reading the letter and read it as a threat to sue, or think that's a reasonable reading of it, as opposed to let's sit down and resolve it, then is your answer to the chief's question any different?
No, I think, first of all, you certainly can defer to HR on that issue. I think that's my point to my brief. I think, though, it may be a little bit unreasonable to do so. But in response to the chief, I think it'd be the same answer. But in conclusion, I'd say here that, Judge, as I said, we have an out-of-state company trolling New York, making cold calls, trying to catch someone. And all we're doing here now, we're not trying to deter them. We're just saying, if you're going to do that, if you want to make a lot of money out of it, be careful with what you do. New York deserves better.
And
Apartment owners
that was
deserve
my
better.
point before, I'm sorry, I'm not recalling getting an answer, and if you've given me one, I'm just going to ask you to repeat it. What steps should they have taken
Meaning a city vision.
to determine that they had a reasonable basis for the complaint?
What they should have done is put in evidence.
Because they've done the tester, right? And then what else should they
They
have
put
done?
in no evidence. The evidence should have been in what we did to lead us to believe that
Yes,
there
but
was.
that's what I'm saying. What would that have been?
Well, now there was a transcript
What's
produced.
the burden on them?
The burden would now to show that, and again, that reasonableness test.
No, not the burden of what they have to show. What would they have had to have done to determine for themselves that they had a reasonable basis? To
Verify
believe
it.
they had a basis.
I think I'd go back to the initial DHR opinion.
Okay.
The decision said, if all they had to do is go to the website and see that they advertise Shenandoah schools. Obviously, they take children. If they had visited the apartment complex, there were children. And then the kicker here is that they said that normally what testers do is they do companion testing.
Well, let me ask you this.
And that was not
If
done.
an individual had actually physically gone in, not just made the call, had the same experience, and concluded, well, they don't want me because of my kids, Would they have had to do the things you just described?
I'm sorry, I didn't catch that
They
last
don't
one.
want me because of my familial status. Would they have had to have done what you've just described? Let me go check the website, let me make sure I'm not wrong about this? Did they have to do that
I
before
would
they
think
filed a
that-
complaint?
I would think yes. I would think yes. I think caution does this. Now, again, there's no basis, our client does not want now to deter the work that testers do. But again, when testers get sloppy and they pursue a bogus claim, as the attorney for City Vision did initially,
But you're saying the burden is the same for an individual, because my hypothetical was an individual. Someone who genuinely, not a tester, someone who genuinely wants to go and rent.
I think that we might want to adjust it a little bit depending upon the, hate to use this statement, depending on the context. But I think there that may be an open argument, Your Honor. And I wouldn't want to commit unless I know a few more facts.
Thank you.
Unless there are any further questions.
Thank you.
I'd like to just address the attorney's fees provision. So 29710 specifies that the commissioner may only award attorney's fees as part of a final order after public hearing held pursuant to subdivision 4 of 297. That is not a separate hearing. Attorney's fees would be available to a prevailing respondent where they had made a motion during the hearing on whatever complaint was being heard.
Right, that's what I was trying to ask, actually, is there a way to read this which would inform what we do here, to say that there's been a legislative decision that if all that happens is somebody files a complaint and it's frivolous, so it meets the frivolous part of it, but the commission immediately sees that and tosses it out, you, the respondent, can't get attorney's fees because there hasn't been a hearing about it.
That's correct.
Only if the respondent has been put to the test of having to go to a hearing under the executive law, could you get fees?
That's correct, yes.
And so then how does that, if at all, affect our decision here?
Well, the argument in respondent's brief that Mr. Pinkowski was just seeking attorney's fees is not in line with the attorney's fees provision in the human rights law. He couldn't have been seeking something he wasn't entitled to.
But as I understand Judge Wilson's question, it's, the court, the hearing officer has just said, I'm tossing this, I'm getting rid of it, no opportunity to have that hearing, and now what else are you left with besides this?
No, in the case of the initial discrimination complaint, the housing discrimination complaint, there was no hearing officer. There was an investigation by the Housing Investigations Unit. They determined after the investigation stage that there was no probable cause to proceed to hearing. So there was never any ALJ involved in that initial case.
So is there an opportunity, I'm sorry,
sorry.
it's just a follow-up. Is there an opportunity to ask for fees in that context?
No, there is not.
So going back to Judge Rivera's earlier question then on the intent of the legislature to use attorney's fees as the remedy, instead of looking at this reasonable basis issue, if you have a completely frivolous complaint that never gets to a hearing, right, and it gets dismissed, similar to what was done here, then you never have an opportunity to get attorney's fees, you're saying, right?
From the division, yes, that's correct.
Right, so that is not a remedy, attorney's fees, that is available to you if someone's filed a bad faith complaint that's dismissed.
Yes, that's correct.
Well, dismissed without a hearing.
Yes, and we term it NPC, there was no finding of no probable cause.
Well, there are complaints and there are complaints that are dismissed without a hearing, but if it's so frivolous on its face, there's not much cost and outlay on the other side. Or what's the experience from the division?
I don't think I understand the question.
Well, I'm trying to figure out what are you trying to remedy as the legislature if it's really frivolous on papers, you're not even at a hearing?
But do they have to respond to you? Would the company submit documentation and try to provide?
That's what I'm
proof
asking.
to you?
Yeah.
Okay, so generally, the complaint is filed, it's sent to the respondent, they have an opportunity to answer it, and then there is an investigation. Sometimes there's a two-party conference, sometimes there are one-party conferences. And then the regional director makes a determination on whether or not there's probable cause. The finding of no probable cause is not the same as a finding that the complaint was frivolous or in bad
Yes,
faith.
correct.
No, understood.
It's,
Correct.
so then you look to if that party then files a retaliation complaint based on their participation in the first complaint, that's when that reasonable basis standard becomes a question.
To be clear, he is correct that the division has adopted this federal standard.
Yes, we've used the standard.
And probable cause is not equal, let me put it that way, to the reasonable basis standard.
No, it's not.
No, okay.
Just one other issue that I wanted to address. The commissioner's findings of fact are entitled to deference, and this court has specified that where the commissioner's decisions are based on substantial evidence in the record, but where the opposite decision is also reasonable based on that record, it is the commissioner's decision that is entitled to deference.
So the court, you would say, substituted its judgment for that of the commissioner?
Yes. It is the division's position that the third department assumed the commissioner's fact-finding role when it looked at the exact same record and merely reinterpreted the facts.
That would be the basis for a reversal. Does there need to be a remittal as well?
I believe if this court thinks that the commissioner's determination that the underlying complaint was made in good faith is not supported, then that does need to be remitted for further analysis on that issue.
Thank you, counsel.
Thank you.